All right, thank you so much everyone for your patience. We will get started. Like I said, the presentation will be recorded, so if you do not want to appear in our presentation, please just turn your video off and we can have a chat at the end. I'd like to say thank you to everybody for joining us. Today's webinar is going to be really informative and have lots of great information for you about advanced care planning and estate administration. So we're really grateful that you are all here to join us and grab some of this important information. I will start by acknowledging the Tasmanian Aboriginal people, the traditional custodians of the land on which we gather today and appear online today. And I pay my respects to elders past and present, and I'd also like to extend that respect to any Aboriginal clients or people who are with us in this webinar today, or potentially watching this in the future online. So we have a panel of experts. We're very lucky to have some expertise here today to join us. My name is Maria and I'm the Marketing Manager at the Public Trustee, and joining me today is Donna online. Maybe Donna might give us a wave. That would be great. Thank you. Donna is an experienced solicitor who's based in the north of the state with the Public Trustee. She joined our legal team last year and she brings over 25 years of experience as a solicitor and high-level estate planning skills. So we're very lucky to have her in our Launceston team. She also supports our Devonport team, seeing people face-to-face and providing quality personal information and estate planning advice to our clients. So thank you very much, Donna, for being online as well. Now, Jeremy, I can't see Jeremy's face, but we've also got Jeremy joining us from the Office of the Public Guardian. He leads a small team or a specialist team to support people when the Public Guardian is appointed as their guardian, or to facilitate mediation when there's conflict relating to an advanced care directive. The team also provides advice and educational materials on related matters. So we're very lucky to have these people with us today to be able to share their expertise with us. We've also got Rachel Valentine, who's joining us online. She's our marketing coordinator, so she'll be helping with support today and monitoring the chat. So thank you, everybody. I'll give just a couple of housekeeping issues that we just need to cover. So again, I'll just state that the webinar is being recorded, and the link can be shared afterwards. So you feel free to visit the content later on. You can share it with a friend or family member or colleagues, because it's really important information to get out there into the community. Everybody seems to be on mute, which is great. So yeah, just if you can make sure you stay on mute, just so that there's no feedback, that would be great. If you wanted to ask a question, please put it into the chat at the side, and we'll either ask the presenter the question at the time, or we will save it to the end and we can answer that question at the end. There will be some time for question and answers at the end of the session. So, you know, if you've got any other questions, you're more than welcome to post it to or let us know then. We'll also be available online. You can email us, you can call us, and if you've got any further questions. I'm anticipating the session will run for about 45 minutes, again, followed by some questions at the end. I just wanted to let everybody know that sometimes it can be challenging to think about end of life and, you know, what might happen to your loved ones if you're gone. So just take care of yourself, and it can be natural for big feelings to come up. So just be more, I guess, wary of that, and just make sure that, you know, you're well supported. But today's session is just information that will be able to help you, give you peace of mind and plan ahead. And it's really important to make sure that, you know, this information is documented, because it is really helpful for your loved ones. It just gives them a bit of guidance and understanding about what your wishes were, and also making sure that they've got the legal documents to be able to follow what you have directed them to do. So it's a bit of an act of care for your loved ones, and making sure that, you know, you're taking the responsible actions and giving them the guidance that they will need at a difficult time. We're hosting this session as part of Law Week. I'm not sure if anyone else has been to any of the other Law Week events, but it's a great annual event that gives people the opportunity to learn about the law and their rights. So there's various sessions that have been run throughout this week about various topics, and we are pleased to be part of this session to be able to provide this information. As you probably saw, that the title of our presentation is When Life Happens, Be Ready. So it's a powerful reminder to make sure that you've got the right plans and the documents in place to help ensure that your wishes are followed and understood. It's a session that sort of, I guess, affects us all. So we all need to make sure that we've, we have an understanding of, what we need to do and how we can plan ahead. So today, Donna will join you shortly, and she'll just explain a bit of information about who the public trustee is and what we do. Then Jeremy will take over and talk about advanced care directives, enduring guardianships, and the role of the Office of the Public Guardian. Donna will come back onto the presentation and she'll talk about wills and enduring powers of attorney. And then we'll be able to, have some time for answers, and we'll wrap the session up as well. So I think we're just about ready to get started. But I will just let you know that the information that's going to be discussed today is intended to be general in nature. It was prepared without understanding anybody's circumstances, so it's not personal advice. We don't understand your personal objectives, your financial situation, or your needs. So before acting on any of the information or advice in this presentation, please consider whether it's appropriate for your personal circumstances. Okay, well, I think, Donna, maybe if you can explain a bit about the public trustee and who we are.
Very good. Thank you for that introduction. Yes, well, the public trustee has actually been around in Tasmania. This is the Tasmanian public trustee, obviously, for over 100 years. So we've assisted generations of Tasmanians with regard to matters concerning their deceased estate, their estate planning and related matters. We've been a government business enterprise since 1995, and we have a statewide presence. We have formal offices in Hobart and Launceston, as well as Devonport now. We also do occasionally broader outreach webinars such as this. So anyone in the state can have their needs met. That's what we aim for. We assist people with the preparation of important estate planning documents, including their wills, enduring powers of attorney, and enduring guardianship documents, which you'll hear more about during the course of this presentation. We also administer deceased estates. That is, when someone is appointed the public trustee to administer their estate as executor, or when other circumstances require it. So there are other occasions when the public trustee can act. We also help people with administration of trusts, including managing money such as compensation payments. So we manage money for lots and lots of people who, for various reasons, can't manage their own. And that includes financial administration of people, where we've been appointed to do so by the Tasmanian Civil and Administrative Tribunal, also known as TASCAT. So we've got a lot of different roles, and essentially it's all about helping people manage their property and assets and money, and helping them with their estate planning.
All right, excellent. Well, we might just get Jeremy to join us.
Thank you. I've just I touched on the take control button and the PowerPoint presentation has disappeared from my screen. Has it disappeared for others, or is it just me that it's?
No, I can see that you've got that I can see the slide there for you, Jeremy.
Right, okay, that's all right then, as long as everyone else can see it. Because I can't, that's all. So I don't have no idea what's on the slide.
Would you like me to take control again?
No,
and
that's all right. I'm just trying to see whether I can bring it back, because it's I don't know why I've got only the participants and not the actual. Anyway, okay. Well, we'll just go with what I can see.
How about I can take control, and then maybe if you just
yeah, that would be good, because otherwise I've got no idea what.
Yeah, no, that's fine.
Yeah. So sorry about that. So thank you, everyone. As you heard at the beginning, my name is Jeremy. I'm the Public Guardian for Tasmania, and we have, or my office has, a broad group of functions under the Guardianship and Administration Act. The ones that are probably most relevant to today's discussion really relate to when we are appointed by the Tasmanian Administrative and Civil and Administrative Tribunal. We also have a function for providing education sessions such as this related to aspects of the legislation, and we have a dispute resolution function which relates to private guardianship arrangements and disputes over advanced care directives, which we'll talk about a bit later on in the presentation. So advanced care directives, which were introduced into the legislation after some statutory amendment a small number of years ago, are intended to provide a legally binding or a legal written document which guides the delivery of medical interventions when a person no longer has capacity to provide that direction themselves. So the Advanced Care Directive it's a voluntary legally binding document, and it's a document that you prepare well ahead of when you will need it. It's one that is best prepared when you have, it has to be prepared when you have decision-making ability, and it focuses on your values and preferences in terms of future healthcare. So essentially what treatment you wish to receive, and often what interventions you don't wish to be provided. It can be done at any age, but it becomes more important when you get older or have complex health needs, particularly where there are particular, I guess, end of life or end stage treatment decisions that you wish to make very clear when you have the capacity to do so. As it says on the screen there, Advanced Care Directive provides consent in advance for medical treatment. So it essentially governs the medical interventions you'll receive or not, allows you to refuse treatment and in what circumstances, and indeed what your personal values are. So what's important to you when you are receiving your healthcare, and I guess what matters to you in terms of quality of life and other aspects of that decision making. Just to reiterate, so when you are making an Advanced Care Directive, you have to make it when you have decision making ability. So it can't be left until there's a question about capacity. You need to understand what an Advanced Care Directive is intended for and what the consequences of giving it is. And it needs to be made voluntarily, and that's a very important point. It needs to be a document you enter into voluntarily. It can't be required by a facility. It can't be required by a residential aged care facility, for example. It is a document that is for you and your wishes and your planning purposes. So a couple of things to think about with an Advanced Care Directive. It's the sort of document that you would complete with your relevant medical professional. Often, most often you're treating general practitioner. They know your health background. They know you well. They are able to provide the language that might be helpful when it comes to using an Advanced Care Directive from a medical point of view. They're also able to consider any chronic illnesses or medications you might be having. The other thing to think about when you do an advanced care directive, and this, I guess, is probably relevant to a lot of the things we'll talk about today, is think about what else you might need to prepare in advance. And so in the case of an advanced care directive, it's worth thinking about an enduring guardian as well. And the reason for that is because advanced care directives are obviously very much limited to healthcare decisions. There may be related decisions which require a guardian order of some description. It may also be that there's a question about the advanced care directive at a particular point, depending on the circumstances, in which case having an enduring guardian that is also familiar with your wishes and personal intent will help treating doctors at when that time arrives. I guess the other thing is that along with, as per any legal form, advanced care directives require they have to be witnessed. You then have to register the document, and it's important for that to occur because essentially the registration of the document is what makes it visible to treating professionals who may otherwise not know it exists. It's not a requirement from the point of view of it being a valid document, but it means that it can be found in an emergency if required. The other thing to think about is if you wanted to change your advanced care directive in the future, you need to have capacity to do that. So again, it's about thinking carefully about what you include in it, consulting with your family, consulting with your relevant medical professionals, and making sure that what's in there is absolutely what you wish. Okay, so and the last thing I just wanted to talk about advanced care directives is probably just and these are sort of a few tips. A lot of people ask what to do with their completed advanced care directive. While it's registered, when it's registered, it's accessible to treating professionals, and indeed they must look for it if you were to come into hospital in those circumstances. It's also worth thinking about making sure that your family's aware that you've got one. So tell the relevant people that you've got one. You can also store a copy online using My Health Record, which is helpful for medical professionals as well. You can store the original in a safe place, so with other important papers that might be necessary at that time. You can have some sort of wallet card or something that you carry with you, which indicates that you have an advanced care directive. The other thing that people quite often do is they will put them on their fridge, for example. So if an ambulance attends their property, it's visible to those sort of treating ambulance staff that there is an advanced care directive in place. So I guess I'm just okay. Enduring guardian, here we go. So I mentioned enduring guardianship documents. They are useful, and I imagine we'll talk about power of attorney and things later on in the presentation. But certainly, advanced care directives and enduring guardianship instruments are an important aspect of planning, which allow for your personal wishes and preferences as they relate to lifestyle and other personal decisions to be reflective of what you wish. It also allows you to appoint an enduring guardian who knows you well and is able to give effect to those personal decisions and is able to make sure that your welfare and well-being is adequately cared for should you lose capacity. An enduring guardianship instrument, importantly, only comes into effect when you are unable to make decisions. So from the time that you prepare it until that point when it's determined that you're unable to make the relevant decision, that document sits there as a plan, basically, and a guide for when it's required. So enduring guardians, as I indicated, they make personal and lifestyle decisions. So that can relate to healthcare and medical treatment, either in accordance with your advanced care directive or in lieu of if you don't have it. have an advance care directive. They can make accommodation decisions, which equally can be a decision to move into residential aged care, for example, or it could be to move into some other form of supported accommodation. They can make decisions around supports and services, so in-home support services, for example. And less frequently, they can also make decisions around contacts and visits. So if there are particular risks or particular people that are problematic, they can make decisions around those, that contact and those visits in the interests of your well-being. What they don't do is make decisions about money, assets, making or changing your will or advance care directive, so they can't make any changes to those documents on your behalf. And of course, anything against the law is outside of their decision-making capacity. So when you're thinking about appointing an enduring guardian, much like an advance care directive, you need to do it at a time when you have decision-making ability, and it is a planning document for the future. So ultimately, it's about doing it at the time that is right for you, but probably when you are thinking about wills and enduring powers of attorney, it's worth thinking about the other aspects of your life as well. You need to understand the nature and effect of the enduring guardianship document, what it will mean and what it will allow the person to do or not, and what you want them to be able to do or not. You can appoint a single enduring guardian to operate on your behalf. Excuse me. You can also appoint a joint arrangement, so that requires both guardians to be in agreement for a decision to be made, or you can also nominate an alternative guardian, so that allows essentially a backup guardian should your primary one no longer be able to fulfil the role. They need to be willing, over 18 years of age, willing, available, capable and responsible, understand what they are agreeing to do, and understand what that means for them, as well as what they will need to be doing for you in that role. Can't be someone in a professional capacity, so it can't be your lawyer, can't be a GP, can't be a paid carer. And in Tasmania, it can't be the public guardian. In some other jurisdictions, it is possible to have your enduring guardianship with the public office, but not in Tasmania. Now, one of the things to think about when you are preparing an enduring guardianship document is the nature of the decisions you want the person to be able to make on your behalf. You can see there on the screen, Section 4, conditions upon appointment. Now, if that's not filled in, what it means is that the person is able to make any decisions related to your personal and lifestyle areas, and it's what's known as a sort of plenary arrangement. If there's particular aspects that you don't wish substitute decisions to be made about, you can write those in there. If you want to limit their ability to make decisions to perhaps accommodation, for example, you would write that in under Section 4 so that it's clear that it is a limited appointment from that point of view. It's also important that if you have done your advance care directive at the same time, that you indicate that on the enduring guardianship instrument as well, so that there's a recognition of the linkage between those two documents. So the registration of the enduring guardianship document, there's a cover sheet available from Service Tasmania. You can see on the screen there that there's fees that relate to the registration and revocation of those instruments. And from Service Tasmania, the document is provided to TASCAT, the Administrative Tribunal for registration. After it's been registered, it'll be returned. The original will be returned to you with a stamp and date. So that's evidence that the enduring guardianship document is ready to be activated. Important question, can you change your mind? And just as you have to have decision-making ability to make an enduring guardian instrument, you also need to have decision-making ability to make any changes. And equally, changes must be registered. Will attract a new fee, but you can amend the conditions or you can appoint a new enduring guardian at that point, should you have the ability to do so. Thank you.
Thanks so much, Jeremy. We appreciate that. Donna, we might just throw to you now, and if you can start talking about what is a will, and then talk about enduring power of attorney.
No problem. Thank you very much. And thanks everyone for joining the webinar today. It's a great opportunity to learn some important information about the importance of having a will and related documents. So thanks for joining us today. A will, most people have a bit of an idea of what a will is, but there's a few myths out there. So I'm just going to go through essentially what a will does and also what it doesn't do. So a will is a document that sets out, in summary, it sets out what happens with your assets and your property after you pass away. So a will only has legal effect from the time of the person who made the will actually dies. Until that time, it's basically a dormant document with no legal effect. But it becomes very important as and from the death of the person who made the will, because it's essentially the only document that allows you, if you like, to speak from the grave and set out who will have important roles in your deceased estate and who will inherit your assets. So what a will does, it deals with property and assets. It doesn't deal with personal decisions, and it basically takes over from an enduring guardianship and a power of attorney. Those documents cease on your death, and your will is the one document that sets out the important things. A will can't deal with things like, for example, how your body should be disposed of. A lot of people do like to include funeral wishes or specific requirements in their will. Technically, those things are not legally valid, but they can operate as an important indication of what your wishes are. But primarily your will should be thought of as a document that indicates who gets your assets after you pass away and who should be responsible for making sure that happens. So the basic structure of a will is it's broken into three main, I guess, components. The first one being your choice of executor. And then the second main component of a will is the details of the will, setting out who inherits your assets and how they should be divided. And thirdly, the powers that you want to give to your executor. So I'll talk firstly about what an executor is and how to go about choosing one. So the executor is the person or persons that who has the primary responsibility for ensuring that your property is looked after your death and distributed according to your will. You can appoint a person, i.e. an individual, as an executor, or you can appoint one or two or more executors to act jointly. You can also appoint substitute executors or an executor to act in the case where the people that you've chosen first can't act. You can also appoint the public trustee in that role. The public trustee will administer a deceased estate according to your will. And as I very, very briefly touched on at the start of the webinar, we do quite a lot of that sort of work. The process from the time that someone passes away until when their estate is fully distributed to the beneficiaries, we call that the administration period. And that can take some time. It can be, in Tasmania, quite commonly 6, 7, 8 months, and sometimes quite a lot longer, depending. And during that time, your executor has to manage your assets and make sure that they're looked after your death, maintained, insured, secured, all those sorts of things. pending distribution to the beneficiaries. In some cases, quite often, in fact, it means that the executor has to arrange for the sale of assets. Your executor's responsibility is also to make sure that any debts that you leave behind when you pass away are paid, and to make sure that your funeral and administration expenses are also paid. So that's a fairly big responsibility of executors. If a grant of probate of your will is required, that's up to the executor to seek that and make that application in court. Probate being a formal grant from the Supreme Court to confirm that the will is valid and that the executor can distribute the estate and administer it according to law and according to your will. So there's a fair bit involved in choosing an executor. For that reason, I mean, you need to think about who to appoint quite carefully. They have to be someone over 18 and who has the capacity to act for you. So a close family member, someone that you trust, is a good choice. A beneficiary is a good choice of executor. And as I said, you can also appoint the public trustee. So if you don't know anyone close enough to you, or you don't have anyone that you'd really trust to administer your estate, you can appoint the public trustee in that role, and we'll administer your estate on a professional basis and carry out all of those tasks that I just mentioned. The next component, or the next part of your will, is the distributive provisions. That is, who gets your assets. And that's a pretty important reason why doing a will is a great thing to do, because it gives you the chance to dictate after your death who gets the money and assets that you've worked hard for all your life. You can make specific gifts, such as giving somebody your car or your house, or personal items such as, you know, that beloved vase that you got from your pop. Or you can just make general gifts. So you can divide your estate into shares and nominate who gets your share, that share, and who gets that share. There are lots of ways you can structure a will. You have a huge amount of freedoms and creativity when it comes to specifying who gets your assets and how they should get them. And you can specify, for example, with beneficiaries of a certain age, if they're under 18, you can dictate what age they should inherit. 18 is considered the minimum, but you can make that age a little bit older if you like. You know, quite commonly people will say, I prefer children to inherit when they turn 20 or 21. So having a will gives you lots and lots more, I guess, say in those sorts of things. So not only who gets your assets after you pass away, but how and on what conditions. If you don't have a will, unfortunately, that means that you won't have that say. And in pretty much all states of Australia, there are laws that dictate who is entitled to inherit your assets after you die if you don't have a will. Another expression for will that you might have heard of is a last will and testament. So we call a person that doesn't have a will, we call them an intestate person. And we have a piece of legislation in Tasmania called the Intestacy Act, and that dictates who is entitled to receive your assets after you die if you don't leave a valid will. Sometimes that can mean that the people you least expect, and perhaps the people you don't even particularly like, will be entitled to inherit your assets if you don't have a valid will. Even if the people you did intend to inherit your assets are the lucky ones. Under the intestacy law, the process of identifying the correct beneficiaries, sometimes even finding them, can take a long, long time. It can take months or years, as opposed to simply weeks or months to distribute an estate. And one of the difficulties for your family and your loved ones is that the estate, that is your assets, can't be distributed to beneficiaries until all people who are entitled are properly identified and their shares are known. So it can cause a lot of stress and a lot of delay for your loved ones. So having a will avoids all of that. There's also a lot of cost involved, which your estate will bear if you don't have a will. Essentially, that means that after you die, if you don't have a valid will, you'll be paying for all the work done by lawyers or administrators to find the beneficiaries and make sure they get their rightful share. So having a will is a really important way of looking after your loved ones, even if you don't have a lot of assets. In fact, even if you only have a little bit behind you, sometimes it's more important to do a will, because otherwise it can be completely eaten up in the legal costs or administrative costs occasioned by not having a valid will. So just because you might have only a small amount in the bank and some sticks of furniture, don't think that means you shouldn't do a will, because in fact that might be, I think the last thing most people will want is to see all their beautiful furniture and whatever money you have left over in the bank end up going to the government or to a lawyer. So just think about those things when you're thinking about, do I need a will? My belief is that everybody over the age of 18 should have a will and should keep a current will, have a current will. That means review it regularly, have a look at your will, pull it out every few years and consider whether it still meets your current needs. I think it's fair to say in this day and age, families change all the time. We've got very different definitions of what constitutes a family now to what it was, say, in the 50s or even 60s, 70s and 80s. So as your family changes, as people marry or separate or form new partnerships, have children, have grandchildren, they're good, basically reasons to consider reviewing your will, to pull it out and see whether it meets your current situation. So it's recommended that you do update your will whenever anything significant happens in your life, such as a change to your family structure or a major change to your assets. And in any case, consider having a look at your will every couple of years to make sure it's up to date. In addition to all of that, it's really important when you're doing a will to understand that they're really technical documents legally. They're very, very complex legally. Even though a will might look very simple and it might only be 1 or 2 pages, there's a lot of law behind making a will. Sometimes even just one word in a will can have huge ramifications. And that's because in the law relating to wills and deceased estates, legal language is really important. And it's important that you get it right and that you understand the meaning of words like property and other, other terms in the will. So doing a will yourself at home might look valid and it might be fine for you and whoever else reads it, but there could be problems. And in fact, homemade wills are a large source of work for lawyers and a large source of litigation, that is disputes that end up in court deciding things like what the will means, what we call construction of the will. There's also strict requirements as to how to make a will properly and make it validly. So things like how it's signed are really important. Things like your deceased estate and the administration of an estate of someone when they pass away, that you really should get advice on before making a will. So there are things like what assets that you have when you pass away will be administered under your will. So your will only deals with property that forms part of your estate when you die. Not all the property that you own or have an interest in when you die actually goes into your estate. So if it doesn't fall into your estate, then your will can't have any say in it. And some examples of that are things like jointly held property, life insurance and superannuation. They don't always necessarily form part of your estate. So when you go to do a will, it's really, really recommended that you seek professional advice. Now, whether you go to see a lawyer or come to the public trustee, that's up to you. But I do encourage you not to make home wills using will kits and so on without at least getting some advice to make sure that they're valid and suit your circumstances. So that's wills in a nutshell. I'm sure I'll have questions to answer during the course of the presentation. So please feel free to type questions in if there's something that you think I've missed. I'll talk now quickly about powers of attorney. So you might recall I said a little while ago that wills have effect only after you pass away. So until you die, your will sits there dormant. In fact, probably no one will even read it until you die, and that means you can change your will. As long as you have mental capacity, you can change your will at any time during your life. Obviously, you know, it's important to have a will that meets your needs and also to an extent looks ahead to deal with situations that might arise, because we don't always, you know, we can't always be sure that we'll have that will-making capacity right throughout our lives. If you lose your capacity to make a will, then you're stuck with the last will you drafted. So having them drafted carefully and professionally is a very good idea. But if something happens to you during your lifetime, that is before your will takes effect, and you lose decision-making capacity, or, you know, just the basic ability to understand what's going on around you and to manage your own money, there is something that you can do to make sure your affairs are still looked after, that your money and assets are looked after, and that your bills are paid. And that's by appointing somebody as your enduring attorney under a document called an enduring power of attorney. Like it sounds, a power of attorney is a power. It's something that you give to somebody that they wouldn't otherwise normally have. So it's an authority, if you like, that you give to somebody to make decisions on your behalf relating to your money, your property, your assets. A power of attorney does not affect decision-making about your health or personal care. So an attorney can't make decisions relating to medical or dental treatment, for example. But what they can do is things like operate your bank account, pay your bills, buy and sell assets for you, things like that. Anything that you can do lawfully with your own property, your attorney can do if you've given them that power under a power of attorney document. When we talk about an enduring power of attorney, we do, the word enduring has a lot of meaning. And the difference is a normal power of attorney that is not a proper enduring power of attorney is automatically cancelled or has no effect if you do lose your decision-making ability or your capacity, which is the legal term for it. So if you make a general power of attorney that's not specified to be enduring and something happens to you, such as, for example, a stroke or, you know, an accident or a misadventure, and you don't have the ability to manage your own property and money, then that power of attorney document will cease to be able to be used. It'll be no good to you. So appointing someone as your enduring power of attorney is kind of considered a backup or an insurance policy to appoint someone to continue to have this enduring power if you do lose your capacity. Because it is a very important document. And for that reason, you know, people who are making a power of attorney need good legal advice to understand what the effects of granting a power of attorney are, what conditions you can specify in it. It is possible to make a conditional power of attorney. So, for example, you can indicate that you only want it to be used for this period of time, a specific period, or only if you have a mental incapacity or a physical or mental disability. But as a general rule, most people grant an open-ended power of attorney to operate as and from the time they've signed it. And the enduring nature of it means, by definition, that if you do lose your capacity to understand what's going on around you and to make decisions, then by definition, you don't know what's happening with your money and property. So you've got to appoint somebody that you trust implicitly. And like I said, you know, get advice before you enter into one so you understand what the full consequences of it are. But they're very, very useful. And if you don't have an enduring power of attorney in place, it can be really difficult for your loved ones, and particularly people that you might, for instance, own homes or other property with. It can be really difficult for them to actually step up and manage your money to make sure, for example, that your bills are paid and that your phone's not cut off, that your car is registered or that your house is insured, all those sorts of decisions that we take for granted. If you can't make them, having someone appointed as your attorney can mean that, you know, for example, you don't go into arrears of your mortgage. In the absence of a properly made power of attorney document, then someone with an interest in your financial well-being, such as a partner or a friend or close family member, would have to make an application to the Tasmanian Civil and Administrative Tribunal for financial management orders. And that process is time-consuming and pretty stressful. So creating an enduring power of attorney where you give somebody that power is a really good way of ensuring that there's continuity in your financial management and that your property is looked after if you lose the capacity to make those decisions for yourself. It's important to know too that once you make an enduring power of attorney, wherever you have your capacity, you can change it. So you can revoke it or change the appointment to appoint somebody in lieu of a person you might have appointed previously. And of course, you can also appoint the public trustee as your attorney to act in the event that you can't manage your affairs. The other important aspect of enduring powers of attorney, like all power of attorney documents in Tasmania, is that even though it might be signed and valid, your attorney can't actually use the power of attorney document until it's registered. So essentially, you need to activate an enduring power of attorney by registering the document. The document has to be sent to or taken to the Land Titles Office in Hobart. The current registration fee is quite a lot. It's $172.85. It will go up on the 1st of July, but it's a really important thing that you understand that a power of attorney can't be used until it's registered. So sometimes people elect to defer the registration of a power of attorney so that it doesn't get registered until it's needed. That's fine if that's what you want. It can save some money in the short term. In the long term, though, it usually ends up in costing more because the fees for registration generally increase over time. And also it can result in delays. So as a general principle, if you can afford to register your power of attorney early, it's probably sensible to do that, but it's not necessary. So that's powers of attorney in a nutshell. And as I said, I'm sure there'll be questions which I'm more than happy to answer. Back to you, Maria.
Thanks so much, Donna. I've got a little slide about enduring guardianships there that Jeremy covered off for us, which was lovely. Look, I'd like to say thank you to everybody for being online. Again, this was really great information. I was nodding along. I've heard this information many times before, but, you know, it's always great to have that information just, you know, presented in a different way. But really, I hope today's takeout is that, you know, take action, prepare these documents. These documents are very important to have in place. Hopefully, for many of them, especially while you're alive, you'll never need to use them and you've got your capacity until your last day. So it is important to have these as a just in case. And obviously, not many of us escape not needing a will, and it's obviously a document that we will need at one stage. So yeah, please feel free to make sure that you look at taking action. You can speak to your local solicitor. You can definitely come and speak to the public trustee. We have a couple of questions that I might go through here before, and then we'll open up. So it looks like that we've got a couple of questions that have come through. So Donna, this might be addressed to you. So when making my will, can the public trustee help me revoke an enduring power of attorney that was made in Queensland, but I'm now living in Tasmania?
Yeah, the short answer is yes, we certainly can help. There are nuanced differences between the states as to the legal requirements, not only for making enduring powers of attorney, but also for revoking them. So we can certainly give you guidance with respect to the steps that you need to take to revoke one that was made in a different state. And we can absolutely help you by making a new one that is valid within Tasmania. So the short answer is yes.
Thank you. And we had another question, which was, at what point is a person classified as having lost capacity and who makes that decision?
Yeah, that's a ripper of a question. I think that's from Tamara. Thank you for that question. Look, who makes that decision? I'll do that first. When we as lawyers see a person to prepare a will or any other related document, we need to, as a matter of law, not to mention good practice, we need to be satisfied that the person understands what they're doing. And there are some factors that are well known to all lawyers that we have to consider when we weigh that up. Sometimes it's really clear when you meet someone that they don't have capacity. So people, for example, with advanced dementia, if you ask very simple questions, sometimes they really struggle to answer things like where they are or what the day is or what they're even here for. So sometimes there are some pretty obvious things that make you realise, this person might not really have the knowledge and understanding that they need to make a will. So that's where you'd probably question whether they have capacity. At that point, we would normally refer the person off to see a GP or a geriatrician, someone with the ability to actually do a proper assessment. So the lawyer makes the initial assessment, but ultimately we're guided by the medical profession as to whether or not the person meets all the criteria to have that capacity to make a will or other document. I hope that's answered your question, Tamara.
Thanks, Donna. Now, Jeremy, this question might be addressed to you. So the question was, what is the advantage of having an ASCD, being an advanced care directive, over an enduring guardianship with Section 9 conditions upon appointment filled out? Setting out what health care and treatment you wish to receive in the future.
Well, I guess the context is important. So in terms of the enduring guardianship document, the Section 4 conditions are really aimed at what areas of decision making the person can exercise. It won't get into a level of detail around treatment or particular healthcare interventions, which the Advanced Care Directive document is designed for. But I guess technically speaking, if you had an enduring guardian who was limited to making decisions around healthcare, and they knew you incredibly well, i.e. they were well aware of what you wished to intervene with or what interventions you wish to receive, it would have the same effect. But the problem would be, and this is the thing to consider, the problem would be for the treating professional, they would be taking the enduring guardian's word for what you wished to occur, whereas the Advanced Care Directive allows you to be much more specific about that. So I think that's in part, that's the reason for having both documents, is one allows you to be very specific about those particular medical interventions. The other one allows for any related decisions that might be required. Hopefully that's useful. There's a lot to take in this session, and I think it's and as it was indicated at the beginning, it's sort of difficult to cover off everyone's specific circumstances, so it is general information.
Yeah, it might be worthwhile. Sometimes even you'll have the link to this video. Yeah. It might be sometimes useful to rewatch it. Okay, we had a question from Tegan saying, is it cheaper to do all three at once? So if you did that with the public trustee, the answer is yes. You can prepare an enduring power of attorney and an enduring and prepare your will for $140 for a single person, $210 for a couple, as long as they're standard wills. When you go through the appointment process, we ask you a couple of questions just to work out whether we classify that as a standard will. But yes, it's very economical to prepare those documents with the public trustee. And enduring guardianship is also at that same price, but that's the same price again. So $140 for a single person and $210 for a couple, preparing those documents. So it is cheaper if you can do most of them in the one document. Just that will and that enduring power of attorney, again, they can be combined if you do it in the one appointment. If you go to a solicitor, that would be a bit more expensive, and you may need to obviously get their rates to do that document. We had another question that was it was mentioned that an enduring guardianship can assist with movement into aged care, but what about the enduring guardian? Doesn't involve financial decisions. The movement into aged care will involve a financial cost. How can the health and financial costs be resolved when an enduring guardian is given no power of attorney or no power of attorney exists? That one might be a tricky one, and might require both of you.
I'll let Jeremy.
I was going to say the short answer is you require both. So that's based on our experience, because there is an accommodation decision, i.e. to move into the facility, and then there is a financial decision, i.e. signing of the lease. So if there was no enduring power of attorney, then it would be an application for administration to TASCAT. And we've seen that increasingly facilities require that as part of the entry into those facilities.
Thanks for that, Jeremy. This is kind of, I guess, on a similar route, but if somebody enters into aged care who has lost capacity and has or have a valid enduring power of attorney and an enduring guardianship, who is best to sign the accommodation services agreement for aged care on their behalf?
That's a bit like the previous question, if I can just chime in there. It's often both. So the authority of the power of attorney or the attorney under the power of attorney document is to enable or authorise payment for the service. So that part of the agreement is an attorney's function. The actual act of admitting somebody into a particular aged care facility, that is authorising their physical placement there, is a guardian role. So quite commonly when people are looking at being placed into an aged care or nursing home facility, the home or the facility will ask to see both forms of authority and ask for both people or the one person, if they're both appointed in both roles, to sign the agreement. I'm going to just jump ahead too, because I can see a question there. Could AI be appointed to make decisions? The answer is no.
And I guess the one above that, which deals with enduring guardianship being activated and working in a GP practice and talking about family members have enduring guardianship, therefore they can act on patients' behalf. Look, ultimately, it is back to that earlier answer around capacity and how capacity is determined. And for treating professionals, often they will make either an informal or a formal assessment around the patient's capacity before they consider the need for an enduring guardianship document or similar substitute consent. So I think it's about assessing the patient's ability before thinking about anything else.
All right, wonderful. Thank you. We don't have any other questions in the chat, and please let us know if we haven't answered your question, if I have missed it by any chance. I might just quickly open it up. Does anybody have any questions that they might just want to take themselves off mute and ask? No. All right, that's fine. If anyone's got any further questions after today, please feel free to get in touch with the Public Trustee. Our telephone number is on the screen there. My name was Maria, and Donna was also on the screen. Thank you for the clap there. We did have some question who had pets. Pets is a very important topic for many people, and they're considered an asset of the estate. Donna, I don't know if you've got anything further that you want to say about that.
Well, yes, pets they often come up in the context of estate planning and preparation of wills. Technically, no matter what your personal view, technically pets are a form of property and you can give them to somebody in your will. If you're not sure what to do, we can assist you with decision making. For example, there are charities that will take pets of people who have passed away and give them a home for life. And we have a fair bit of information that we can provide people when it comes to making a will to make sure their pets are looked after when they go. Hope that's a sufficient answer.
No, wonderful. Well, thanks everybody. We might wrap today's session up. I think we've gone over our hour time slot. So thank you very much for being with us taking on board that information. As I said, we'll be available, via the telephone if you've got any further questions after today. We would really appreciate it if you can give us some feedback about today's session. So hopefully we'll have either in the chat there'll be a link to our survey, or we will send it to the participants as well to complete that. So it'd be lovely to have some feedback about how this session was and whether there's any improvements that we can make. But otherwise, I will let you all get on with your day. I wish everybody well, and thank you so much for joining us. And again, thank you to Donna and Jeremy for being our expert panelists and in providing all that important information. And also thank you to Rachel for all your support today in setting this presentation up. So thank you so much, everybody. All right, take care. Have a wonderful day.